The day after the Voting Rights Act was gutted, North Carolina started passing these really insane rules and regulations for voting, which is why it's so freaking hard to vote in our country. And a lot of states did. Texas was one of them, too. New ID requirements. They eliminated same-day registration. They reduced early voting by a week. They blocked a law that would let 17-year-olds pre-register if their birthdays were, if they would turn 18 before November, let's say this year it's November 8th. If they would turn 18 before the second Tuesday or the first Tuesday in November, then they could pre-register. They'd be all set and ready to go on it. Also, if you went to the wrong precinct and you cast a ballot, they threw, they used to count it. Then, North Carolina said, oh no, we're just going to throw it away. Your ballot gets thrown away. Well, a federal court today struck down all those requirements. There was a lower court that said, oh yeah, that's fine. A local court, see? And that's why I'm saying all these racial issues, they cannot be decided locally. They can't be decided even within the states that are being accused of bigotry or targeting or, racism. They just can't, because everybody knows everybody, especially in the smaller states. It's just a ridiculous thing. There are 50 people in politics per state that have a say in any of this, stuff. So anyway, went to a federal court, and the appeals court said, no, you can't do that. You can't do that, because they said the intent was clear. And the intent was to keep African Americans from voting. So F you, Scalia, in your grave. You were wrong again, just like you were wrong about the Second Amendment, just like you were wrong about Citizens United, just like you were wrong about the Voting Rights Act and the gutting of it. You have been so wrong for so long that it must be a relief to be dead now, because now you no longer can be wrong. You're just dead. So they said that the intent was obvious, and that the intent was to prevent African Americans from having their votes count. And it was, this is what the court wrote. They said, in holding that the legislature did not enact the challenged provisions with discriminatory intent, the court seems to have missed the forest in the carefully surveying the many trees. This failure of perspective led the court to ignore critical facts bearing on legislative intent, including the inextricable link between race and politics in North Carolina. The intent was to discriminate against African American voters in North Carolina, and the court pointed that out and said to the legislature, really, who do you think you're freaking fooling? We know what the intent was. And no, you can't have your little restrictions. Okay, can't. It violates the law of the federal government. It's not within the Constitution. It's not within your constitutional right to do that. And so those vote. But remember, we just went through an election with those laws in place. Those laws apply. The case didn't. I don't think the case was brought until March of this year. And so people had to comply with those rules and regulations and those laws in this last election.